Hello, folks. Another chapter from SQE1 window, and we will explore case law and statutory interpretation in our session today. So, in order to understand, case law, or what I like to call it, like how judges make law without admitting they do so, they don't. So, at that point, they develop law. I would say, they improve law. They just try to just get new interpretation of law. So the doctrine of precedence, precedent we call it, not president, is also named as stat decisis, means stand by what has been decided. We already talked about it in our previous sessions. It keeps the law consistent and predictable, though some would say it also keeps judges safely predictable too, but it is not in some cases. Courts must follow earlier cases with similar facts, especially when decided by higher courts. It's all about order in the legal universe, like Hogwarts. So, but with Whigs and Latin at that point. Sometime I hated Latin, but now I love. So let's talk about finding precedent and hierarchies, everything you need to understand. Which court binds other court. So at the top sits the Supreme Court. It binds everyone else but can ignore its own past decision, though it does so very politely and very rarely. Then we have the Court of Appeal, bound by Supreme Court and usually its own decisions, except for the famous Young versus Bristol exceptions. Remember, conflicting decision, Supreme Court overrulings, or decision given by per incuriam, that fancy Latin for whoops. We forget something important at that point, that's per incuriam kind of things. The High Court binds lower courts and is persuasive to High Court judges. Everything below county court, crown court, magistrate court must follow a lot, a bit like younger sibling with no real choice in a family. So another concept that is ratio decidendi and obiter dicta. Maybe I pronounce it wrong. Apologies. So here, where law scenes start sign dramatically. The difference between ratio and obiter. So need to understand that the ratio is the reason for decision, the legal principle essential to the outcome. That's what binds future courts. Obiter is different. That is, by the way, comments judges make that sound impressive but are not binding. However, if said by Lord Dunning, they tend to become persuasive gospels. In exam, look for the judges like legal reasoning connected directly with the decision. That's the ratio. Everything else is dinner table philosophy. That's it. That's obiter. It does not mean that's dinner table philosophy, but that's persuasive. A lawyer can quote it in front of judge, and judge may take it or not, but ratio will be binding. Take it. Judges are clever. They can sometimes dance around precedents without breaking them. Number one is distinguishing, means saying the case is different, often because of some tiny factual variation, the legal version of spot the difference. Overruling happens when a higher court declares an old decision wrong, a bit like sending it into early retirement. Reversing occurs in the same case on appeal, for example, and of course, persuasive precedent come from places like other Commonwealth courts. For example, it can come from India. It can be dissenting opinion that I don't agree with this decision, or even scholarly writing, maybe my articles. Yes, your future articles or my articles can become persuasive that we write in research journals. So what are advantages and disadvantages of precedent? Precedent has its charms and headaches, of course it is. The good bit, it creates certainty and consistency, helps predict outcomes and develops law in practical steps. Bad bits, that's too much of it. It can be rigid and sometimes judges twist distinctions so much that the law looks like, well, what it is. I don't understand. A complex maze and all. Still, it keeps the system stable, predictable, if not always poetic at that point. So rules of statutory interpretation, we have a load of them. We need to understand, and that's what is examined in SQE1 sometimes. I found a couple of questions from here. So when Parliament writes an act, it is clear until when you read it. So judges then try to find what Parliament actually meant. They have four main tools: the literal tool, the literal interpretation, we call it, or literal rule, we call it, whatever you may call it. Use the plain meaning of the word, even if it produces absurd result. The golden rule: tweak the literal meaning to avoid absurdity. Mischief: ask what mischief the statute was meant to cure. And that is Haydn's case from 1584, before Netflix, before coffee shops and all. So at that point, you need to look at, like, if we need to interpret the law as text says, whatever, or we tweak it in a way that we avoid absurd meaning of the text. And then we look at mischief, like, which mischief the law was made for. And of course, purpose. If, like, we got it, the modern method, focusing on the purpose behind the law, especially for EU and international context. That what Parliament really wanted to do it in that one, and that's what we can get it from parliamentary debates and all. So, aid to interpretation: how to get help once you are interpreting as a judge. So judges do not guess blindly. They use aids to interpretation. Those are internal. Those are found within statute. For example, the title, preamble, section headings, or definition clauses, all of it. Even punctuation may help, though that's a risky business in British drafting. So external aids include dictionaries, earlier statutes, case laws, law commission reports, or Hansard, that we got it, like a record of parliamentary debate. So after Pepper versus Hart, 1993, Hansard can be used, but only when the act is ambiguous and there is a clear ministerial statement on the point. In other words, Parliament's version of "I meant what I said." So that's what you need to keep in mind as a judge and as someone who is sitting in SQE. So the next thing is presumptions and rules of language. Judges also rely on presumptions, interpretive habits that reflect common sense, and centuries of caution. They presume Parliament does not legislate retrospectively, that criminal law requires mens rea, and the Crown is not bound unless expressly stated in the cases. So those are the things which are common sense. And then there are Latin phrases you must love, or at least memorize. So these kind of justum generis, general words limited by specific ones before them. So another one: mention of one thing excludes other. That once it specifically mentions one, it means it excludes other. That this applies on this, it means it does not apply on others as well. A word is known by its neighbors, the same similar words and all. The Latin makes it sound ancient, but the examiner still adores it. So these kind of things, I didn't pronounce a couple of them, so at that point, maybe you are better. You can pronounce them, but be mindful of the fact. Just try to have a grasp of them. And I used to do it in my own way. I used to pronounce it in my own way and associate it with some concepts and memorized it. So, SQE tips. So first, always know who binds whom in hierarchy. If it is Supreme Court, no, it binds everyone. It is County Court, it does not bind anyone. So next, tell about, try to just understand what is a ratio and arbiter. Ratio is binding and arbiter is persuasive. Examiners sometimes they love to test it. Young versus Bristol, it is an exception. Just try to keep in mind it will come, at that point. When tackling statutory interpretation question, identify which rule applies. For example, is it literal? Is it golden, mischief, or purposive? That's what sometimes is tested in exam. And in my exam, I found this one. I wish you all the best with your exam for SQE and overall LLB and understanding these concepts. I hope this helps. Thank you very much for joining us. Ta-da!